The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to the session of the Kansas Supreme Court. I want to welcome Kansas Council as well as all of those of you who are watching on our Supreme Court Live channel. This morning we do have one justice who is not is recused from the case. Justice Wilson will not be sitting on this appeal. She will not participate in any aspect of the consideration of the issues or in the decision. We will proceed with this case with 6 justices, as no one has been appointed to sit in her place. With that explanation as to the change of our makeup, I would ask Mr. Doug Shima, the clerk of the appellate courts, to please call the 11 a.m. docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Friday, December 18th, 2020 consists of one case. Appeal number 120017, State of Kansas versus Ronald D. Morley, Shawnee County, briefs both sides. The appellee petitioner has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, I would ask that you would enter your appearances for the record.
May it please the court, Your Honor. James Heathman, appearing on behalf of Ronald Morley and ready for argument.
May it please the court, the state appears by Assistant Attorney General Stacey Edwards.
Thank you, counsel. Mr. Heathman, you may begin with your argument.
Thank you, Chief Justice. This is a case that arises from a decision by the trial court to depart from the sentencing guidelines and impose a non-prison sanction on Mr. Morley as opposed to the presumptive prison sentence. The state of Kansas appealed that decision from the trial court to the Court of Appeals. The Court of Appeals thereafter had determined that essentially 2 issues: that the trial court did not have substantial competent evidence to find the departure factor in which it had indicated, and secondarily, that even if it did have sufficient competent evidence to find that factor, there was not a substantial and compelling reason to depart. We had sought review. The court granted that petition, and that's what's currently before the court. I will address those 2 issues in order. Again, first being the Court of Appeals decision to, in determining, I suppose, that there was not substantial competent evidence upon which to find Mr. Morley had accepted responsibility. The acceptance of responsibility was the factor, according to the trial court, that it used justifying departure.
Counsel.
Yes, sir.
Can I interrupt right there?
Certainly.
I am confused by the factual setup here, because it looked to me in reading the transcript at the sentencing hearing that the judge not only referenced accepting responsibility by Mr. Morley, but also the concept that having him out on probation would give him the opportunity to make good on his acceptance of responsibility about the financial consequences. And I'm confused how that can be considered one factor. It seems like there's 2. But then you had the clarification later that said, no, my only factor here is acceptance of responsibility. Can you help me understand what happened with that? And am I right that being out on the street so he might be able to pay these people back was a factor for the court in departing?
Yes, sir. Thank you for the question, Justice Biles. In answering that, I do believe it could have been broken down into separate factors. On the clarification hearing that we had, the court, I think, made clear that there were specifics within the category, kind of the umbrella of acceptance of responsibility that he was considering, but they all were informing his opinion and his view that there was acceptance. And yes, being out on the street and an ability, at least a desire and an effort to make restitution and payback was important to the judge, to the trial court. But I also think he analyzed it in a little different way as well, because it was Mr. Morley's willingness to pay restitution. It was his desire to pay these people back and make them whole that informed his opinion that Morley had accepted responsibility. In other words,
why is the willingness to pay restitution even a factor? That's irrespective of Mr. Morley's willingness to pay. That's just something that's subject to a court order and is almost required in situations like this. I don't understand how that's a factor. Explain that to me.
Well, Judge, I think that speaks to the trial court's analysis and figuring that it's the willingness and desire to pay that demonstrates acceptance. Somebody who is truly accepting responsibility has a desire to make people whole, has a desire to get them paid back for the losses he had caused. And it's that.
I guess I'm a little confused about willingness to do something that you have to do.
Well, you may be forced to do, Justice, a variety of things, and you may do them unwillingly and disgruntled, unhappy about it because you don't think it's fair or appropriate. And in that scenario, you may not really be accepting your role in the reasoning for paying it back, even though you have to do it. So I do think there's a distinction between somebody willing to do it and desiring to do it in terms of recognizing their level of wrong, as opposed to somebody who simply is forced to do it. It doesn't like it, doesn't agree with it or accept it, but they're forced. And I think there's a distinction between those where one could be said to be remorseful and wanting to make people whole, and the other just doing what he's told. Also, I think it's important in the acceptance of responsibility factor is that the record is replete with evidence of Mr. Morley's acceptance of responsibility. He admitted his role. He admitted that he didn't give information that he should have to the individuals. He admitted that he made statements that were misleading and that he allowed them to be misled, and then that caused their loss. Also, then we've already discussed the issue of restitution, his willingness to pay it back, his desire and remorse he demonstrated to the court. He had, in one section of the record, I think very introspectively, talked about how he recognized the harm that was caused was generational. It was not just to a particular individual, but the impact went far beyond just an individual. And so I think that demonstrates the awareness, remorse, and acceptance as well on behalf of Mr. Morley. So I think the factor that the trial court found upon which to base its discretion, its discretionary act of departure, I think the evidence was clear on the record that it existed. The Court of Appeals did not agree that that evidence existed. And the record, I suppose, speaks for itself. Mr. Morley accepted the no contest plea knowing he would be subject to a jail sentence. And I would draw a distinction between the no contest plea and an offered plea. The Court of Appeals seemed to be maybe looking at in terms of whether this was really compelling or truly acceptance, as to this idea that pleading no contest could maybe never really be the basis, although there's no bright line rule for that, because one may not truly be accepting responsibility by saying no contest. And I think that's likely the case if we were talking about an Alford plea. An Alford plea being, as the court's aware, someone who says, I'm going to get the benefit of a plea bargain, but I'm really not guilty. I didn't really do that act, but I'm going to say guilty just to get the benefit. That's different than a no contest plea. But it seemed to me in reading the opinion, the Court of Appeals really equated the two in concluding Mr. Morley, by pleading no contest, wasn't really accepting responsibility.
Well, there is a significant difference between a no contest and a guilty plea when it comes to civil liability, isn't there? A guilty plea is essentially an admission in a civil context. A no contest plea then leaves the plaintiff or whoever is seeking compensation has to prove it. A no contest plea is not an admission. And in particular, in cases like this, isn't that significant?
Well, I don't believe that's significant, Justice Rosen, because the restitution would be ordered and control that question. So whether there was civil liability, there was liability imposed by the criminal court. The real impact of the no contest plea at the time was Mr. Morley maintained his license for insurance to sell insurance in Maryland. And he had a long history in business and a significant income from that life insurance and health insurance business. And he wanted to maintain that license so he could pay the restitution. At the time of the sentencing, that license was still in place. And so he was looking at finding or using the no contest plea to put himself in a better position arguing in Maryland to maintain his license. So that was essentially kind of the motivating or a motivating factor behind that. It really had no impact on civil liability, as the courts indicate. He's going to be responsible for restitution anyway.
Counsel, I kind of disagree with you on that. So why don't you push back on me? It seems like on the issue of civil liability, the fact that he does not plead guilty is going to at least impact the ability in a civil case to get punitive damages. So it seems like even though the restitution order may have covered the actual damages, the restitution order doesn't cover that aspect of what would be civil liability. So it seems like there is still some hedging going on.
Well, and I appreciate that question. I'm not sure I looked at it from that aspect of punitive damage, but I would note that his plea of no contest, while not an admission to be used against him in a civil case, it certainly does not preclude a civil case being filed in which punitive damages could be sought. And the record of his plea and his statements in the criminal context would certainly be something that would be relevant and used in a civil context determining any punitive damages. So it certainly wouldn't preclude that if any of the injured individuals wanted to go through that civil process seeking the punitive damages. Secondary issue, briefly, Judge, it looks like I'm out of time. I've reserved, or justices, I've reserved 3 minutes. So if I can just sum up for a moment, or would the court prefer me to stop?
No, go ahead and sum up, Mr. Heathman.
Okay, we didn't really get to argument on the issue, but once the court found the first issue, they went on to analyze the second as if maybe they hadn't, what would happen if kind of scenario. And in that context, it seemed to me to say that they could really just reweigh all of the evidence, that the determination of whether or not there's a substantial and compelling reason to depart could be made by the appellate court without any deference at all to the trial court. There's that's the 2001 McKay decision. And then there was some language in Hines and Byrd later on that say, well, it still has to be under the abuse of discretion standard. So I think there's some interplay between just a blanket review for substantial and compelling reasons to depart where we give no deference versus whether or not we need to look to see whether the trial court's determination of that factor, and that factor being substantial and compelling, whether that is an abuse of discretion.
Well,
I don't think the Court of Appeals had to analyze it from that point.
Counsel, it does seem to me that there are some mileposts in this second analysis. In other words, the sentencing statute doesn't say if the district court finds a compelling or finds a mitigating fact, a reason for departure, it may depart. It still anchors the discretion in the concept of it being substantial and compelling to do so. So it seems like this is abuse of discretion with some guardrails, more guardrails than we would normally have in an abuse of discretion kind of case. That makes sense?
It does make sense, Justice Biles. And I think, I mean, that was one of the reasons to proceed on this appeal and petition for review, because I don't think that's really clear now. If the court is saying in the context of departures, the review for substantial and compelling reasons to depart is not just no deference at all to the trial court, but is really an analysis of abuse of discretion with some additional parameters, guardrails, as you will, then I think we need guidance to say that, because that's unclear at this point. With that, Judge, I will end my argument and reserve the remaining time for any rebuttal.
Any other questions of Mr. Heathman? Okay, thank you.
Thank you, Justices, Chief Justice.
Ms. Edwards?
Thank you, Your Honor. The state agrees with Mr. Heathman that there's really two issues involved in this case. Number one, was there substantial and competent evidence supporting the existence of the sole departure we have, acceptance of responsibility? In other words, is that a departure factor even on the table for consideration? And then secondly, assuming that factor gets on the table, there's enough evidence showing it exists, was that factor a substantial and compelling reason to depart in this case? And the state believes the answer to both those questions is no. That factor doesn't exist, should not have been considered by the court. But even if it was, it's simply not a substantial and compelling reason to depart from the presumptive sentence of imprisonment in this case. So on that first question, the substantial and competent evidence question, Justice Biles had mentioned, well, aren't there maybe a couple more factors that were considered that were thrown into the mix? And here we've got a really nice clean record. The district court very clearly stated it was only looking at that one factor, acceptance of responsibility, but then it listed out the evidence that it found was substantial and competent, namely his acceptance of responsibility through the no contest plea, and then his acceptance of responsibility as shown by his willingness to pay restitution. The state's position is that neither of those circumstances, neither of those pieces of evidence are substantial and competent in this case because of all the attenuating statements, all of the other circumstances, the record, defendant's statements mitigating his responsibility throughout the sentencing hearing. The Court of Appeals kind of briefly dabbled with the question of whether a no contest plea could ever result in acceptance of responsibility, but the state's not asking this court to go that far today. The no contest plea, as Justice Rosen indicated, is significantly less valuable than a guilty plea when it comes to accepting responsibility, because that's the very nature of a no contest plea. The defendant is admitting the state can prove its case, but not actually admitting guilt. So here, while the no contest plea doesn't preclude acceptance of responsibility, in this case, it doesn't rise to the level showing acceptance of responsibility. In fact, the district court—
Ms. Edwards, why not? I mean, I appreciate, my point was that there's a distinction between the consequence of a no contest plea and a guilty plea. but the end result is the same. And they're completely informed at the plea hearing that the consequences of a no contest plea is going to be a finding of guilt. So why isn't that at least a consideration of that if that is competent evidence of accepting responsibility?
That's true, Your Honor. A no contest plea does result in a guilty plea, but the motivations of the defendant may come into play, the mitigating statements at sentencing, there's civil judgment to think about, and that's all within the defendant's prerogative. The defendant can choose to plead no contest, but that does cut against acceptance of responsibility, especially when, as here, that no contest plea is accompanied by many, many statements disclaiming responsibility, criminal responsibility for his conduct.
But let's separate out for a second whether the defendant's acceptance of responsibility under these circumstances would constitute a substantial and compelling reason to depart. But just as a gatekeeping matter, this is a non-statutory factor that the court is injecting. And you can't deny that the guy accepted responsibility. I mean, he stood up there and said it. So, I mean, it seems like it exists, right? So shouldn't we be moving the the trial court didn't make that up. It happened. So shouldn't we be moving further downstream in the analysis to really wrestling with this notion of, under these facts, is this good enough for the district court? It's just a substantial and competent reason to depart. You see what I'm saying? I'm just moving down the road more.
Absolutely, Your Honor. So that I will turn to issue 2 then, but I do want to note that unlike Thoyer, which is the case that our Court of Appeals cited quite a bit in this opinion, we don't have a creditability determination that the district court thought the defendant, was accepting his role, was really being honest with the court about his involvement. For example, the Court of Appeals said that he wasn't impressed with Mr. Morley's insistence that he was only a consultant. And he wasn't impressed with Mr. Morley's attempts to blame other people in the investment company for the ultimate loss. So I would say in this case, the Court of Appeals wasn't really looking at, okay, does he actually feel sorry? The Court of Appeals was looking at the mere fact of the no contest plea. And that is part of that second inquiry, that substantial compelling reason inquiry. District courts, appellate courts are supposed to look at, all right, the factor you've got, how good is it? And in this case, it's just not that good. For example, during the sentencing hearing, counsel stated that Morley's involvement, this is a quote, Your Honor, his actual fraud, if you will, is failing to disclose that he had a prior SEC order, if you think that's fraud. We didn't concede that. We've got statements that Mr. Morley is accepting responsibility, but then when you look at the transcript in context, what is he accepting responsibility for? He's willing to admit that he didn't do his due diligence. He's willing to admit that he trusted the wrong people. And he states many times that he's simply a conduit for Summit Trust Company, the company that ultimately ended up being a Ponzi scheme. But that's not what he was charged with. He was charged with fraud. He was charged with intentionally misleading Kansas investors by failing to disclose a ban from selling securities that would have mattered to the victims, and the district court found that, by failing to note that this was not a low-risk investment, but rather a high-risk, no-liquidity investment, all of which was known or should have been known to him, and he failed to disclose because he wanted to get his commission. So yes, he says, I accepted responsibility, but what he accepted responsibility for was not doing due diligence. And that's not enough in this case to show that he accepted responsibility to the extent that there's a substantial and compelling reason to depart from the sentencing guidelines here. I'd also like to point out that the Court of Appeals looked at a couple of other factors too. Mr. Morley did concede that the harm was generational, although he minimized his responsibility for that harm. But that's part of why the Kansas legislature created a special rule for sentencing in securities cases, that if the loss amount is more than $25,000, It's a presumptive prison offense, no matter where you fall on the grid. Well, here, the loss was approaching $850,000. And I think the victims made very poignant, very compelling statements during the sentencing hearing about not what that money was, but what it meant to them. That was the loss of blue-collar worker generational wealth. That was the loss of college funds. It was the loss of a dream wedding, whatever it may be. That money meant a great deal to them. And because they're older, they're not going to be able to make that back. The harm here is significant, which really contrasted to Mr. Morley's willingness to pay back only his commission money, $50,000 at first, really belies any argument or conclusion that he accepted responsibility in this case to the point necessary to justify a departure. So the state still believes there's not substantial competent evidence in the record to indicate he accepted responsibility in the first place. That factor shouldn't have been on the table. But even if it was, the district court should not have granted a departure in this case because any acceptance of responsibility was minimal. His willingness to pay restitution was limited to what he earned in commission, which is not the measure of restitution or harm to the victims. We've got a special sentencing rule for securities fraud cases, $25,000 or over. We've got exceptional harm to the victims here. And under these circumstances, Mr. Morley's willingness to admit that he failed to do due diligence is not enough to compel the district court to leave the sentencing guidelines behind, which is the standard in this case. I do want to turn just briefly to the transcript itself. I've already read, Your Honors, the bit about the fraud, but I also do want to briefly talk about the fact that that was not his only crime of conviction. He was also charged with and ultimately found guilty of acting as an unregistered issuer agent. In other words, he sold the securities to the Kansas victims without being properly registered to do so. And as to that offense also, Mr. Morley was just not able to come out and say, I did it, here's what I did, I understand that I'm criminally culpable, and I will pay full restitution. And that's what the state was looking for here. During the sentencing hearing, Mr. Morley often mentioned that he was trained to say certain things by the trust company. He acknowledged he wasn't licensed to sell securities. He says that only licensed people are responsible for telling the Kansas investors, showing them the offering memo, going over it. And then he says, yeah, if I presented the memo, then I would have been selling securities. But he also claims he never presented the memo. So it's not clear what Mr. Morley thinks he was charged with, apart from generally putting his trust in the wrong people. The state routinely asked him, why did you say it was low risk if you didn't know it was low risk? And he just doesn't have an answer. He wants to blame other people, specifically Summit Trust and other related defendants. And that's certainly his prerogative, but it doesn't show acceptance of responsibility. So in conclusion, unless there's further questions, the state would ask this court to affirm the Court of Appeals. There's not substantial competent evidence that Mr. Morley accepted responsibility in this case. Is no contest plea, given all of the minimizing statements in the transcript, doesn't get him there, and his willingness to pay restitution doesn't either, especially considering he only wanted to pay back his commission, a drop in the bucket compared to the victim's actual harm. But even if that factor gets on the table, the district court abused its discretion in finding that that reason was substantial and compelling, considering the harm to the victims, the severity of the offense, the purpose of the Kansas sentencing guidelines, our special legislative rule, and of course, the limited value of his acceptance of responsibility here. And if your honors have no further questions, that the state would just rely on its brief and ask that this ultimately be remanded for resentencing.
Any questions? Thank you, Ms. Edwards.
Thank you.
Mr. Giesman, you reserve 3 minutes for rebuttal.
Thank you, Your Honor. I want to address a couple of issues, if I may, quickly. Right off the bat, I think we see a distinction and the difference. Maybe it was confusion on the lawyer's parts, but Mr. Morley was charged with in count one, the securities fraud. And specific element was that he either made untrue statements of material fact and or omitted to state material facts necessary in order to make statements made not misleading, essentially. Mr. Morley could commit this offense by omission or commission, saying specific things that weren't true or omitting certain things that people had the right and should know. He admitted the elements of that offense. The state has a little different theory in argument, but at his sentencing hearing, during the initial phase when counsel was addressing the restitution question and the overall overarching facts of the case, the prosecuting attorney made clear to Judge Brown that Mr. Morley's offense is one that he would be found guilty of regardless of the conduct of Summit Trust Company. Summit Trust Company did the Ponzi scheme. Morley assisted and defrauded people, not giving them adequate information and helped them get there. Morley had nothing to do with the operations on what they did with the money or where it went. And the state recognized that and made that statement to the trial court. Mr. Morley would be responsible for his crime regardless of whether the individuals made money or lost money through Summit. That's important because I think that's when the state views Mr. Morley's statements in response to the prosecuting attorney as minimizing, what he's doing is distinguishing, this was my role in what I did, and this is what other people did, that wasn't my end of it. And so I don't think he's minimizing, I think he's distinguishing his role. And the other reason that's important is because Mr. Morley never objected to paying restitution. Mr. Morley never said he didn't owe it or shouldn't pay it. The state presented three figures to the court, three different ways or amounts that the court could use, one of which was Mr. Morley's actual commissions. That was the figure the Federal Securities Exchange Commission used that Mr. Morley had to repay or has to repay. Mr. Morley was arguing to the court, my role, my offense, if I'm guilty of it, irrespective of what happens with Summit Trust Company, then the damages from my conduct might be different than the damages from their conduct. And whatever the right number is, Judge, you tell me and I'll pay it. That's what Morley's argument was. That's what he addressed with the trial court. He's willing to pay whatever the right number is. He didn't appeal this case. He didn't appeal the restitution. The Court of Appeals indicated that he continued to argue for lower restitution throughout his appeal. That didn't happen. He didn't contest that. He wanted to get whatever the right number was, and he wanted to get it paid. Having said that, I think there's really a danger. It almost appears as if the Court of Appeals is saying, if you have money to pay restitution, then that could be a factor. And if you don't have money to have a plan or to afford to pay the restitution in a reasonably quick time, well, that shouldn't be considered then. And I think that really gets into a dangerous area. I don't think the Court of Appeals intended to go there, but from reading their opinion, it really seems like that's the direction they were headed. And I think that's problematic. I apologize, Judge. I see I'm over time, and I will answer any questions or at least try to. Otherwise, I will end my argument and just ask that the trial court opinion be upheld.
Are there any questions? Okay, thank you, counsel. I would thank both counsel for your arguments today. The court will take this appeal under advisement, and we are in recess until 1:30 this afternoon.